Hello, my name is Daniel Bong and I will be presenting the introduction to our project. Firstly, we must understand what a prospectus is. So, firstly referring to section 226 of the Capital Market Services Act, which we will be referring to extensively throughout this project. In this section, it states a prospectus means a notice, circular, advertisement, or document inviting applications or offers to subscribe for or purchase securities. Making reference as well to section 242 subsection 1 of the CMSA, it is stated that where an issuer allots or issues or agrees to allot or issue any securities with a view to any of them or all of them being offered for purchase, the document by which this offer is made will be deemed as a prospectus. From these sections, we may see an emphasis on the offering of security for purchase. Thus, we come to an understanding that a prospectus essentially is a document to advertise the purchase of securities. With this knowledge, what is the importance of the law governing a prospectus? For the answer to this question, we refer to a report by the so-called Davie Committee, which was empowered in 1894 to inquire what amendments were necessary to the British Companies Act at the time to better prevent fraud. This committee reported its conclusions together with a draft bill the following year, in 1895. Thus, this committee gave recommendations, essentially that there should be more requirements than mere formalities before a company is allowed to issue a prospectus. Some examples of these recommendations were: 1. That a copy of the prospectus should be required to be filed with the registrar before allowing the company to issue it to the general public, so that the registrar could then make sure that the required information was contained therein. Another example was to disallow any allotment of shares before the minimum subscription had been ensured. Reference must also be made to the case of New Brunswick and Canada Railway Company v. Muggeridge. In this case, the court stated that the issuer of a prospectus must state everything therein with strict and scrupulous accuracy, and not only abstain from stating untrue facts, but also must not omit any fact which might materially affect the nature, extent, or quality of the privileges which the prospectus uses and mentions to induce the purchase of the shares. So from this, we understand that a prospectus is a document advertising the purchase of shares. There's also a great importance in ensuring that a prospectus is accurate, so that it may not be used as a tool for fraud to take place. Thus, we will move on to the next presenter to explain the procedures required to register a prospectus. Thank you.
I'll be talking about the procedures. Firstly, application for approval from Securities Commission. By virtue of Section 213 subsection 2 of Capital Market and Services Act 2007, an applicant seeking approval for matters provided under Section 212 shall make an application to the Commission for approval and shall submit documents and information to the Commission. Second, the requirements to register a prospectus. According to Section 232 subsection 1, a prospectus in relation to the securities must be registered and complied with the requirement before it can be issued, offered or subscribed. Next, according to Section 232 subsection 2, a person shall not issue, circulate or distribute any form of application for securities unless the form is accompanied by a copy of prospectus which has been registered by the Commission under Section 233. By virtue of Section 232 subsection 7, a person who contravenes subsection 1 and 2 commits an offence and shall on conviction be liable to a fine not exceeding 10,000 million or imprisonment not exceeding 10 years or both. Third, the registration of a prospectus. In accordance with Section 233 subsection 1, the Commission may refuse to register if the prospectus does not comply with any provision of this Act or the prospectus contains any statement or information that is false or misleading. Based on Section 233 subsection 2, in order for prospectus to be registered, it must be submitted to the Commission together with a written application for its registration, copies of all consents required under Section 244 subsection 1, and copies of all material contracts referred to in the prospectus. Fourth, the lodgement of prospectus. By virtue of Section 234, an issuer shall cause a copy of the prospectus registered by the Commission accompanying such prospectus in relation to securities other than a unit trust scheme or prescribed investment scheme to be lodged with the registrar, and also to a unit trust scheme or prescribed investment scheme to be lodged with the Commission before the date of issue of the prospectus. Thank you.
Good afternoon, everyone. My name is Tamila Supani Silvam and I am from Group 28. Today I'm going to talk about the registration requirement. For this, we have to look at the Section 231 of the Capital Market Service Act. It said that a prospectus in relation to the security must be registered and comply with the requirements before it can be issued, offered or subscribed. Meanwhile, Section 232 stated a person shall not issue, circulate or distribute any form of application for security unless the form is accompanied by a copy of prospectus which has been registered by the Commission under Section 233. In Section 232 sub 7, a person who contravenes subsection 1 and 2 commits an offence and shall be convictable liable to a fine not exceeding Rm 1 million or imprisonment not exceeding 10 years or both. This can further explained in the case of Kwek Lee Chi against Attorney General 1985. In this case, it was held that a conviction for not issuing a prospectus when one is necessary is an offence in connection with the promotion, formation, management of a company and attract a 5-year disqualification from directing, promoting and managing companies. Next one is we're gonna see few exemptions for registrations, which is Schedule 6 and the Schedule 7 of Capital Market and Service Act. Talk about the excluded offer, invitation and also issues. Section 229 says that an offer for subscription or purchase for invitation, subscribe or purchases securities excluded offer and excluded invention. The offer invitation is specified in Schedule 6 or B. The offer invitation is made to a person, a class person or made in respect of security. Lastly, Section 230 says an issue of securities an excluded issue if subclause A, the issue is specified in Schedule 7 or B, issue made to a person, class person or made in respect of security, class of security. Thank you.
Greetings and a good day to a respective lecturer that is watching this. My name is Loy An, and today I'm going to be presenting about the 4 other requirements of registering a prospectus of a company. So as explained earlier by my friends, there were 4 first requirements and then I'm going to explain about the next 4 requirements. The 5th requirement is of registering a prospectus is the refusal of an exemption. Now, as stated in Section 233 or subsection 1 of the CSMA 2007, that the Commission can refuse a prospectus if the Commission is of the opinion that the prospectus does not comply with the provisions of the Act, or issue of offer for subscription or purchase of or invitation to subscribe for purchase securities to which the prospectus relates does not comply with the requirements or the provisions of the Act. C, which is Commission is of the opinion that the prospectus contains any statement or information that is false or misleading. Next is issue of offer for subscription or a purchase of or invitation to subscribe for or purchase securities to which the prospectus relates requires the approval of the Commission under Section 214 and such approval was not given or does not comply with any term or condition imposed under Section 214. Relation to unit trust scheme or prescribed investment scheme. There has been a failure to comply with any term or condition in relation to approval of a management company or trustee. And lastly, Commission is of the opinion that the issuer has contravened any provision of security laws or of the Companies Act, and that such contravention would cast a doubt as to whether the issuer is fit. Now, the prospectus will not be approved for registration if the contravention of a prospectus is not the provisions of the law stated under 233 subsection 1 is not followed. Now, the next requirement is the exposure of the prospectus, which is stated under section 232 subsection 4 of the CMSA, whereby it states that the Commission may, for public information, publish registrable prospectus submitted to the Commission before registration of the prospectus. Now, the second last, which is also the 7th requirement for the registration of the prospectus, is a registrable prospectus, which means that a prospectus has to be submitted under section 233 of the CMSA and which has yet to be registered by the Commission as purported under section 202 subsection 6 of the CMSA 2007. And the last requirement for registration of prospectus is the consequences of the registration. Section 235 subsection 1 subsection B states that if the prospectus without any prejudice to subsection 236 shall state that the registration of the prospectus shall not be taken to indicate that the Commission recommends the securities or assumes responsibility for the corrections of any statements or opinions or reports expressed in the prospectus. This means that the company will be liable for any misleading or false information that has been stated in the prospectus, and it cannot shift the blame towards the Commission, and everything that is said, then they are liable for anything that is written in the prospectus. That's all from me. Thank you very much, and I will move on to the next presenter.
Good evening. I would like to begin by explaining what is its meaning and the purpose of prospectus of a company. So a prospectus is a legal document used for describing a company's securities that have been put on sale. So this document known as prospectus is used to disclose the company's operations along with its purpose of the securities being offered. And besides that, it is designed to provide information and full details about an investment offering for sale to the public, and companies must be required to file the documents with SEC, which is also known as Security and Exchange. And what are some examples of prospectus? So an example of prospectus is an IPO. So the prospectus tells its potential shareholders about the company's future and business models. And for insurance and investment, a prospectus lists out the objectives or product inclusions and exclusions and fees. So ETF, the prospectus inform likely invention, its goal, history, and other financial details. What are the importance of a prospectus is that besides containing the details of the company's business and financial statements, it is also to help to notify the public of the issue. It is to establish accountability on the part of the directors and promoters of the company. It also helps the company to be on record. And what type of prospectus are there? So there are a few types. One of it is the deemed prospectus, the red herring prospectus, shelf prospectus, and also the abridged prospectus. So the contents of prospectus are specified in the Companies Act, which covers over the details of the company such as name, registered office address, and objects. So details of the signatories of the memorandum and shareholding particulars, details of the directors, details of shares offered and the class of issue, as well as voting rights, minimum subscription amount, the amount payable on application, on allotment, and other further costs, underwriters of the issue, auditors of the company. So the audited reports regarded profit and losses of the company. So in conclusion, since you are my client, the best advice I can give you is to be well aware of the procedures and the following requirements to register a company's prospectus as followed in the mentioned relevant sections. So once a prospectus has been registered, it will be lodged with the ROC before the date of the issue of the prospectus. So besides being aware of the contents of the prospectus, it is also an obligation to have a duty of disclosure in light of the Companies Act 2016 and the Capital Market and Services Act 2007. So that's all from me.
Good day to everyone. Hello, I'm Amudin Tilenathan. I'll be concluding the project 1. As my friends have briefly explained about, gave an introduction and also about the procedure, the requirement from first to fourth, the requirement, the entire requirement, and also the content of prospectus. Now I'd like to conclude that that the company can be changed into a public company. There will be no issues. It is very important to follow the procedure, and it is also very important to satisfy all the requirements that is required to change a company from a private company into a public company. So as a conclusion, I would like to conclude that the company can be changed into a public company. Thank you.